L2. Got it.
Oh, yes. Good evening, everyone. Welcome to Master Mortgages. Your lecturer today is Ms. Christine Archer. Hopefully, you've all received, well, some of your course materials. As soon as Ms. Archer revises the schedule, I'll go ahead and forward that to you as well. All the classes will be recorded. We will start every day at 6:30. And hopefully, please, folks, I need you to, once you sign it, please use your name. No iPad, Samsung like that. Please use your name so we can take the register. But that's done, said and done. I'm going to turn it over to Ms. Christine Archer.
All right. So good evening, everyone. Let me see if I see any familiar names. Don't look so that I know. Okay, so this is Mastering Mortgages. You will see from the beginning of the manual that it gives you a guideline as to how to study for the course. During the course, we will discuss some Bahamian cases that are related to the topics we're going to study. There is one final exam, which is comprehensive. The exam is scenario-based. And of course, it will require you to refer to case law where applicable and to the legislation. So I would suggest that you read your chapters before you come, pay attention, write notes, ask questions. If there's something that you find when you're studying through the week and you have a question, you can always email me. With that, let's go around and let's everybody introduce themselves. Start with Ashley.
Hi, good evening, everyone. My name is Ashley Carey. I am a registered nurse. I work at PMH. So my background is healthcare, obviously. I'm excited to join this course because it allows me to concentrate on something other than my respective field. And a bit nervous because this is going to be, this is really an introductory course for me.
Okay, that's fine. Like I said, if you have questions and things you don't understand, you're welcome to call or send an email, and then if it's necessary, we can chat on the phone so you can get more clarity.
Okay.
Okay, that's not a problem. Okay, Siobhan.
Hi, good night.
Good night.
Hi, my name is Siobhan. Sorry, can you guys hear me?
Yeah, we can hear you.
Okay, my name is Siobhan Major. I'm a paralegal at BRF Chambers. Yes.
Okay.
Right.
All right. Camille.
Good evening, everyone. My name is Camille Simonet. I am currently employed at Commonwealth Bank. I work in our credit department, so I'm just trying to get a better understanding in mortgages. So I'm looking forward to see where this course takes me.
Okay, that's very good. Darius.
Good night, I'm Darius Adams. I'm an officer on the Royal Bahamas Defense Force, inspiring homeowner, and I'm just looking to see what I can get from the course.
Okay. Kevin.
Good evening, everyone. My name is Kevin Farrington. I'm a part of the credit committee of the Law Enforcement Cooperative Credit Union, and my interest is to gain more in-depth knowledge about mortgages.
Okay, excellent. Okay, Lisa.
Pleasant good night. My name is Kaisha Thompson. I'm from Bahamas Law Enforcement Cooperative Credit Union Limited. I work in the loans department, and I'm here just to get more in-depth information about mortgages.
Okay, fine. Terrell.
Hi, good night, everyone. My name is Terrell Smith. I'm a butler supervisor at Rosewood, Bahamas, studied hospitality. This is more of a new sort of industry for me. I'm basically looking into purchasing a home, and I want to get some more detailed information about mortgages and how to go about it, and basically to follow the right format.
Okay. All right, Tony.
Good night, everyone. I'm Tony Simmons, Grand Bahama
You're breaking up, Tony.
Cooperative. I do a mortgage from A to B when they need it, time, A, and at the right time.
Okay, so you
But it's a
actually,
pleasure to be here. I meet everyone, and but I
okay,
was in
Tony,
your last class.
which last class?
You fading out, Miss Archer. You fading
You,
out.
oh, I couldn't get you because you're going in and
I
out.
fading out.
Yes. What did you say?
Yeah,
You're not.
I was in your last class.
Yes, I
Yes.
recognize the name, but I have to make sure.
Yeah, I was in the last class.
Okay, all right.
So I came
So-
back because I need some more clarity on it.
Oh, okay, all right. Not a problem. Okay, let's go to Wendon.
Good evening. I'm Wendon Miller-Fraser. I'm an attorney at Ian Cargill & Co. Taking this course, I guess, is a bit of a refresher, or I guess more so to pick up on the nuances in local property law, because I primarily do criminal. And I'm
Mhm.
licensed abroad, so most of what I know is US based. And I sat in your class, I don't remember if it was tax or wealth management a couple years back.
Okay, all right. Yes, I remember the name now. Okay, Felicia.
I need a 10 here.
Or Tanisha. Is she on? I see she. Okay. Well, that's the last member of the group. So again, welcome everyone. We do have some new people, and some who are coming for information purposes. So I like to have the class be, the book is written at a point in time. And so if there are things that you come across or things that you have experienced that you want to share, feel free to stop at any time in the class. As I think the more. So everybody's okay with that? I guess so.
Sorry, I didn't hear the last part. You were breaking up just now.
Again?
Same
Yeah,
here.
we didn't get you.
You didn't
We
get
lost
me?
you.
Okay. So what I was saying was that everybody is at a different point in terms of the subject matter. And so whenever you want to share or you have questions that you want to ask any one of the colleagues within the group, feel free to stop me and ask. I prefer the class to be interactive, because you get more out of sharing with each other. It's okay now? Everybody heard me?
Yes, noted.
Yeah.
Okay.
Yes, ma'am.
Okay. All right. So let's begin. Tonight is chapter 1 is the introduction. Then, well, with the first one, introduction to land law. It's not that long, but there's a lot of terminology, and you have to begin to understand how law is defined in the Bahamas. So because everyone always say they have property. So property means ownership. And when you talk about the law of property, you're talking about ownership and any rights that are connected to that property. Oh, someone just joined. Jeffrey.
Good evening.
Good evening. We're just starting. Just
Okay.
introduce yourself and where you work.
Okay, so my name is Jeffrey Cooper. I am a trained teacher at C.I. Gibson.
Okay. And you're doing the course
I'm sorry, I think there may have been a slight disconnection on my end. Can you repeat the question, please?
No, I was asking if you're taking the course just for information.
Yes, ma'am.
Okay, all right. Okay, that's fine. Welcome. All
Thank
right,
you.
so, okay, I'll start again. So, property. Property in law means ownership. And with ownership, there are rights. So when you talk about land, you're talking about land and rights to that land. So property is ownership, and property has to do with the law of ownership. And to know what ownership means, then you go a little bit further, because ownership is the right of a person to enjoy that property as fully as the law permits. That's what ownership means. So when you say you own this piece of property, it means that you have the right to enjoy that property as far as the law permits you to. Or it can mean that you have a right to assert that something is your own. That's what ownership means. And that's a right that can be asserted against anyone else. And you'll see that when we discuss some of the cases dealing with adverse possession. Means that someone else is saying that the property belongs to them, rather than the person who is saying that I have ownership of this property. So ownership itself has 3 rights. They call it the Trinity of Rights. The first one is you have a right of using, which means that when you own property, you have exclusive use to that property. And the owner may not use the thing himself, but he can also prevent others. So that means that you could have a piece of property, you can fence it in, you're not going to build anything on it, but it is yours. And you can prevent anyone else from using that property. Means that someone else cannot come and build on your property. The second right that you have is of profiting from that property. And that means that you as an owner can rent your property, or you can get dividends or shares from your property if you structure it as a holding company, holding an asset. The third way is using up, that's alienate. So that means that the owner can diminish the value of the property. So say someone has a piece of property and it has a hill on it. They could diminish the value by knocking down the hill and selling the dirt or the curry, whatever it is. Or you could destroy the property. You can take the property inside to dig holes in the property, whereby if someone wanted to now buy that property from you and build a house, they're gonna have to fill it back in order to have a proper foundation. Or you can transfer the ownership to another person by either selling it or giving it as a gift or any other reason. But all in all, when you say you own a piece of property, always remember that ownership means rights. And in those rights, there are 3 of them. Now, when you own a piece of property, you could lose possession of that property. Losing possession doesn't mean that you lose the title to that property. Losing property that one merely possesses means that you lose physical control of the property and any right to exclude persons from controlling it. So in addition to those rights, the Trinity of Rights, there are other rights that go with land. So under the class of property, you have easements, and you have profits, and you have restrictive covenants. So ownership of a thing can be regarded as a right in or a right to that thing. And it's possible to own a right over or against a thing owned by another person. And when you say thing, we're talking about what right you have to that land. So when you talk about easements and profit, easement is a right over one piece of land that attaches to and benefits another piece of land. Profit is like an easement. It's a right to go onto another person's land and diminish it by taking something away. And is a promise that is made in a deed. So even though it's a part of the law of contract rather than property, covenants given by one landowner to another may continue to be enforceable by and against successors in law. So that means that when a lawyer does research, if there is a restrictive covenant that has been placed in the original deed, depends on the wording of that deed, that covenant runs with the land. Now, it says when you own property, you own that property in terms of exclusivity and control. But it also speaks to when you lose, you could lose possession of it. And it says, but you don't have to lose the title to it. So the true ownership or the nature of ownership is entitled rather than ownership. So that means when you say you own land, you're not owning land just by talking about it. You're owning land because you have papers to say you own that land in terms of possession. So property law concentrates on the fact of possession. So if anyone wants to assert that he has been dispossessed of his land, he didn't have to prove that he is the true owner. It's the other person who is challenging him has to now prove that he has a better right to that possession. Because always remember, an earlier right to possession is a better right to possession. Because whoever has the earliest one is the one who's now claiming that they are in possession and they have exclusivity to that property. So when a person says, I possess that land, I have ownership of that land, they're saying that I have exclusive use and control of that property, but with no rights or title to the property. So possession means that you have evidence of ownership. And the person in possession may have continuing physical control over the item and any intention to exclude others from controlling it. Now, normally when you deal with land and you intend to purchase land, you always have to insist on formal proof of ownership. And formal proof means that the vendor has to provide the proof by producing title deeds in the form of a certificate of title. And the title deeds will demonstrate the strength or the weaknesses of that vendor's title. Your right in possession of the land, and it also allow you as the purchaser to ascertain whether there is any risk that someone else may come later down and say that they have a better claim to be in possession of that land. Any questions so far? No, we're good. So let's look now at things capable of ownership. Land is always looked as being capable of ownership. But there are other physical things that are capable of ownership. You have clothes, food, you have cattle. These are physical things and they're referred to as chattel. Otherwise, the law also recognizes intangibles, such as patents and copyright and shares. So when it comes to property, real property and personal property. Real property is comprised of freehold interests in land, and we're going to discuss what freehold means very shortly. Personal property is tangible and intangible properties, items that are not considered to be freehold. For example, personal property may comprise leasehold interest in land, but it also could hold chattels personal rather than chattels real. So personal will be cars and boats and jewelry. The chattel personal is then divided into choices and action. Choices and action is property which does not physically exist, such as patents and copyrights and goodwill. And choices in possession are things like books and clothes and computers. Now, when you refer to a bank taking on a security, where there's a legal or equitable charge, those are looked at as choices in action. So we've looked at property and ownership, what it means to have possession, exclusivity, and also looking at there are other types of items that can be called ownership. And with that ownership, we found out that there are rights. In addition to the Trinity of Rights that come automatically with ownership, there are other rights, such as easements, profit, and restrictive covenants. So now you turn to land. What is land? So land can include real property, the building, any structures on the building, and the rights over that land. And the rights over that land can be the rights of way, or it can be an easement, or it could be mining rights. Land does not refer or doesn't include fixtures because they are not attached to the land and the building. So always remember, land, realty, or real property is always distinguished from personality or personal property. So land itself, and there's this whole study of land law, relates to rights over land rather than to land itself. So the students who are thinking about or aspiring about purchasing a home, you will see as you go through the course that you don't really own the land, you own the rights. Yes, you're going to purchase a piece of land. You're going to make sure you have title to that land. But always remember that when you purchase that land, you're purchasing rights. So when a customer mortgages his freehold land to the bank as security, he in effect restricts his freehold rights of ownership by giving the bank rights of security over his land, either by a legal or equitable mortgage. And in such case, the land is not affected, only the rights over the land. Any questions to that? because you have to understand the concept. No questions. So when you talk about rights over land, there are two types of rights over land. You have legal rights and you have equitable rights. And legal rights could either be a legal estate or a legal interest. A legal estate is a right of ownership. And that right of ownership entitles you to possess or occupy the land. And that's when you talk about freehold ownership. And freehold, when you say you own a land or piece of land as a freehold or with freehold interest, it means that there is no obligation to a superior tenant, which means that no one has a better title than you in respect of that land holding. So whenever you own something, if you want to apply for a mortgage, you have to, your property itself has to be a freehold estate, because you must have owned it fee simple absolute in possession. And you'll see that if you have an existing mortgage now. Fee simple absolute in possessions means that the estate in land can endure indefinitely, and it could pass either by sale or gift by the freeholder, or it can pass by will, or it could pass under the rules of intestacy to another person. So that means that if you have ownership of land, and there's no other person who's challenging the ownership of that land, you own that land outright. You are the owner. Your estate in land can pass by you selling it to someone else, you gifting it to someone else, or you could write a will and devise that property to someone else. Or if you die without a will, then the law determines who will have that property. So absolute means that it is unconditional. In possession means that you as a freeholder, you're either in actual possession, which means that you're actually on that land, you're living on that land, or you have a right to receive rent, which means you have a building on there and someone is paying you rent. Or you could have leased either the land or you lease the building and you're getting profit from it. So that's a freehold estate. You can also have a legal estate. And that's where the tenant derives the estate from a superior tenant who may be a freeholder. So you have a piece of land, and then you decide that you own it fee simple absolute in possession, but someone wants to lease that land from you. And let's say they want to lease it from you for 99 years. That person becomes a leaseholder. The person granting the lease is called the leaseor or the landlord. And the person receives the lease is the tenant or the lessee. So even though there is a leasehold arrangement, the freeholder still has his freehold interest during the continuance of the lease, because it's not a sale. After which, once the lease is expired, it reverts back to the freeholder. So whenever you hear someone say they've leased a piece of property or they've leased this building, it's always for terms of years absolute, which means the lease may last for a fixed period of time, unless, of course, there's a termination clause in the agreement or there's a breach. So fixed term leases are of a certain duration, are the only lease that may be useful as security. So yes, you could use a lease as security. And remember that the leasee can also lease that property to someone else for a lesser term. So an interest in land is a right to a claim against the land of another person that is less than the claim to possession. An interest in land can be legal or equitable interests. So a legal interest is a right over land that is given to a non-owner, but it's still valid against everyone. And it gives the non-owner a right which is less than the actual possession as a legal estate. So when you talk about a legal interest, meaning a right over land, you're talking about a permanent right of way over a neighbor's land, which gives the non-owner the right to cross over that neighbor's land, but you don't take possession of it. So an example of a legal interest is an easement, a right or privilege over the land of another person, by a charge by way of a legal mortgage, or a rent charge, or charge imposed on land by law. If you notice, sometimes when persons live on a piece of land, their houses one behind the next one, but they have to pass the first house and the second house to get to their house. That's what they're talking. Or right of entry. There's a right to rezone possession that's given to a lessor of a lessee. So equitable interests are legal rights, and they are valid against anyone who has notice of those rights, actual or constructive, at the time of the property transaction. So a bona fide purchaser for value of property, and bona fide purchase of value of property means someone who purchased a piece of property without any notice and who had no means of knowing that someone else owned that property. So a bona fide purchaser for value of property who purchases the property without genuine notice of the equitable rights over it may acquire the property free of those rights. So that means if you have no knowledge, there's no way you could have known, and you purchased that property, and then someone comes behind now, they're saying they're suing you and that you had constructive notice, which means that you should have known based upon the information, and you are able to prove that you had no. Then you become a bona fide purchaser for value without notice, and you could acquire that property free of all those rights. So some examples of equitable interests are equity of redemption. An equity of redemption means the right of a mortgagor to redeem the mortgage property upon payment of the outstanding principal and interest. So that means that once you are granted a mortgage, you have a schedule of when to pay. And if you decide that you want to pay off the balance of your mortgage, then you can go ahead and pay it off, principal and interest. Equitable charges is interest in land that's taken as security for a loan without creating a formal legal charge. And of course, restrictive covenants. And that's agreements or undertakings where one person promises to restrict the use of their land for the benefit of another person's adjoining land. So in law, there may be both legal and equitable ownership of a legal estate in land. And the legal ownership in land gives legal title to the estate. And the equitable interest in land gives the right to benefit from the estate. So it is possible in law for one person to be and another person as the equitable owner
Sorry,
of the same property.
Ms.
can you
Archer.
repeat that for me, please?
Yes.
You blank out. You blank out
Oh,
the whole
okay.
time.
So I was saying in law, there may be both legal and equitable ownership of a legal estate in land. So that means that one person could be recognized as the legal owner and another person as the equitable owner. And you normally see this type of arrangement when you have a trust. So when a settlor, that's a person who wishes to create a trust, he has assets. And let's say his assets is land. Now he wants to create a trust. And in order for him to create a trust, he must first have the freehold estate in that property. It must be in fee simple absolute in possession. He owns it outright. No one has a better claim than he to that property. He then transfers the legal interest in that property to the trustee. The equitable interest is for the beneficiary. So unless the settlor makes himself a beneficiary, he has no rights to that piece of land. So where the legal and equitable interests are separate, the legal owner can dispose of the legal interest and the equitable owner can dispose of the equitable interest. So a legal owner could create either a legal or an equitable obligation or mortgage, whereas an equitable owner can only create an equitable mortgage over the land because he only has an equitable interest. Now, besides talking about ownership and having interest in that land, you also have to talk about co-ownership. And co-ownership means when it's more than one person that owns a piece of land. So where two or more persons hold an interest in land at the same time, you call that co-owners. And there are two types of co-owners. You have joint tenancy and you have tenancy in common. So joint tenancy is where two or more persons each own the whole interest in land. They do not have separate and distinct shares. This prohibits any one owner having exclusive possession of the whole or any part of the property. So joint tenancy has this feature called right of survivorship. So this means that when one person dies, the other person takes that share. Joint tenancy, there cannot be more than 4 legal joint tenants of land. A tenant cannot sell or mortgage his or her legal rights, as a legal joint tenancy cannot be severed in law. However, a joint tenant may sell or mortgage Now, if you look at tenancy in common, that's
Yes.
where two, go ahead.
Ms. Archer, you cut out on the last part.
Okay, joint tenancy.
Yes, ma'am.
Okay. So joint tenancy is where you have two or more persons, each owns the whole distinct shares. So with joint tenancy, there's no 50-50, 60-40. They just, and it prohibits any
Miss
one of them
Archie, your
from having
connection
exclusive
gone
possession.
again.
It gone again? Why is it going
Yeah.
off and on? It's not blinking on my own. I don't know. Okay, let's try. Okay, so joint tenancy each own the whole
You're
interest in the
gone. You're
land.
gone. We can't
They
hear
don't
you.
have separate and distinct shares. Oh Lord. Why is this happening tonight? Hold on, let me see something. Oh, I see what's happening. You can hear me now?
I
Hello. You can? Okay.
We can.
Okay, I think this is the internet. It's doing again. Spinning around and around and around. Yes? It's going and coming in.
That's what's happening because you blanking out every couple of seconds.
In a couple seconds, say, oh Lord. Okay, so.
So we lost.
Oh Lord, don't say that. Okay, tell me where you are.
Joint tendency.
Tenancy.
Tenancy.
Yeah, tenancy.
Yeah.
T.
At least
Oh, making more noise.
Tenancy. Yeah.
Yes. Okay, so. Oh, making more noise. No. So joint tenancy, that's where two or more persons own a piece of land. Each own the whole interest in the land. They don't have a separate share. Already 50-50. So it means that both of them together own the land. And the feature of joint tenancy is what we call the right of survivorship, which means that when one person dies, the other person then owns all of the property. You can't have more than 4 joint tenants of land. And one tenant cannot sell or mortgage his or her legal rights, as the legal joint tenancy cannot be severed in law. However, a joint tenant may sell or mortgage his or her equitable rights. So a tenancy in common, however, is when 2 or more persons own land jointly but undivided shares. So that means that each owner has a share in the land, which may be equal or unequal. And with tenancy in common, there's no right of survivorship. So that means that if the land is between 2 persons, let's say it's at 60-40, and the person with 60% dies, then that person's 60% is included in the disposition of their assets. So it's either included in their will or follow the rules of intestacy. Difference between the two. So when it comes to land in the Bahamas, you know, Bahamas has unregistered land. Other jurisdictions in the Bahamas have registered land, where you can just go look up a piece of property and find out exactly who owns it and who owned it all the way back to the crown. But we have unregistered land. And that means that the freehold title to land is denoted by possession of title deeds. And those title deeds include abstracts of title, conveyances, mortgages, release of mortgages, searches, assignments, and scheduled of lists of documents. So that means that when you go to purchase a piece of property, and then a lawyer has to do a search, all of these things have to be done, and they're all done manually because we have unregistered land. Whatever collection of deeds or title documents that the lawyer is able to obtain, they will show the chain of title, concluding with the person who's selling the property now The last document will show where that person purchased the property from the previous owner. So on record, the person who is selling the property is the last legal owner of record. So an unregistered land, the owner of the land transfers his ownership by deed. And deed is a written transfer of the land. So a purchaser or a mortgagee investigates the seller's title and any other matters affecting the land and its value before purchasing or lending. So as you can see, if you want to, if you're going to purchase land or you're going to enter in a mortgage, you need an attorney. And that is because the land is unregistered. So title to unregistered land is not only shown by possession of title deeds, but also by the seller demonstrating to the person who wants to buy that land or his attorney that he has title by showing what we call a good root of title going back 30 years. So not because you have that deed in your hand where it says that you purchased this property from Mr. X means that you own that land and you can sell it. You have to be able to prove that you have good root title, which means going back that 30 years. Title to land in Bahamian law is completed by two-stage transaction. First, you have an agreement or contract for sale. And this binds the purchaser and the seller to complete the terms and conditions in the agreement. The agreement in itself does not transfer the title to the property. Under the agreement of sale, the vendor has to produce for the purchaser or his attorney an abstract of title, showing evidence that the title goes back to 30 years. Can be a conveyance, it could be a mortgage, or it could be an assent. And an assent means that's a legal document showing where you transfer the legal estate from the personal representative of the deceased who owned the property and who has now, you're going to legally inherit it under the
Hi, Ms. Archer.
intestacy. So when someone, go ahead.
Ms. Archer, I have a quick question.
Go ahead.
Let's say, for example, John Doe owns 2 acres of land, right? And he sells 1 acre of that land to Peter Roll. Now, the access road that would take you to both John Doe's property and Peter Roll's property is now on Peter Roll's property. And so the persons who own parcels of land on John Doe's property cannot gain access to Peter Roll's, well, they can't gain access to neither property unless Peter Roll gives them access. How can something like that be cured? For the easement cure that?
Yes.
And
Now,
then
for that piece of property, that's why it's always important when you do the search. Yeah, you have to see if there was an easement at the very beginning.
Let's say there was no easement. And I guess Peter Roll, for whatever reason, sold John Doe sold the property to Peter Roll without ensuring that the access road to both parcels of land, I guess, wasn't like a fixed access road. So he sold the property, and now the original vendor, the original owner, can't access his parcel of land because he sold, I guess, what's his name, Peter Roll, the property. with the access road on it. I don't know if you understand what I'm saying.
Yeah, but hold on. So is 1 acre of land.
No, let's say it's 2 acres of land.
Okay, so there's 2
And he-
acres of land
And
owned
he sold,
owned by John Doe.
yes,
Okay. And then he sold one piece to Sally and one to Mary.
yes.
Okay. And you're saying now that Sally cannot get to her one piece because she has to pass through Mary.
Yes. So it may not be exactly 2 acres. It may be 2 point something acres.
Okay.
And so
And so
the point something acres, I'm thinking he should have used that as the access road to gain access to both sides of the property. But he initially sold the point something acres to Sally. So Sally owns the 1 acre in addition to the point something acres that should have been the access road.
mm.
I know, but explain it right.
Now you gotta start. I'm drawing it as you're talking. So I'm getting now. This goes back now to the surveyor. What did the surveyor do?
Well, the surveyor may have messed up from jump start.
Yeah, you see, board. When you own a piece of property, before you sell it or you purchase it, you get a surveyor, because you got to make sure that first that this piece of property and also that there is access. So when this was sold, he should have made sure that there was access to back property.
When you
And
say
then here
he,
comes,
you mean the
and then here
surveyor, or
comes
you
the
mean
lawyer now. The surveyor first, and then the attorney.
Okay.
You see, but it starts with the surveyor, because the surveyor is the one who's going to draw to say this is where the line is. These are the stakes, and then all the thing the lawyer is going to do is draft the document based upon what they say. So now the question comes in: how can the person at the back now get access to this property?
Yes.
That's
So that this would be the I guess the attorney would be responsible for
the lawyer to come up to see how much. You got cut off.
No, I was asking if the lawyer would be responsible to clarify.
Yes, the same one. Yes, the same one.
Okay. And if
The
that's
same
something
one.
that he missed, then what would come out of that? Let's say if he didn't do his whole assessment on the whole land to make sure that you do have access to that, and it's basically a flaw from his on their side, being the lawyer, because that's his responsibility.
Right, but hopefully you wouldn't have to go to court. If you don't have to go to court, then maybe he may do the services at a reduced fee, or I doubt he'll do it pro bono.
Okay.
Yeah. Anybody else have any questions? They're awfully quiet. No questions?
No, ma'am.
Oh, hold on. I think the internet is acting up all over. So at the end of the chapter, I have the legislation. Property Act, the Law of Property and Conveyancing Condominium Act, the International Persons Landholding, the Registration of Records Act, Real Property Tax, Stamp Duty, VAT, the Quieting of Titles Act, and add to that also the Homeowners Protection Act, which we will go through later. Let me go begin other parts of the chapter. So you understand how co-ownership works, because a lot of people normally have questions about co-ownership. tenancy in common, and joint tenancy. No questions there. Is that as clear as can be?
Yes.
Okay. So let me see if I can ask you a question. I'll see if you understand it. Let me see. Let me see. I know I wrote something down to ask you. Where did I put it? Okay. So let me give you an example. If, let's say someone owns, there's a house and 4 persons own that house as tenancy in common, A, B, C, and D. What happens when A dies?
Hello?
Yes, go ahead.
You said tenancy in common?
Yes.
And 4 persons owns it, and if 1 person dies, then the person who died, that goes to you could probate the estate or administer the estate.
Mm-hmm.
Right, and then the other 3, they still basically own in there whatever shares they had in the property, but the person who died, let's say if they had a spouse, well, with this new law, half would go to the spouse and half would have to split equally between the children.
Yes. And down the list as it goes for inheritance.
That's right.
Everybody knows how assets evolve on intestacy.
No. Can you explain it, please?
Okay. Who was speaking just now?
Sorry, before we move on to the question I was asked just now, where did the children come in just now? Like
Oh,
I
I'm about to say,
understood.
okay.
Okay.
Okay. All right. I'm going to explain it to you right now.
Thanks.
And don't sound like you're getting angry with the children. Okay. So, you know, when a person dies, will, a properly executed will, that means that you died testate, or you could die without a will, and that's said to be intestate. So when you die with a will, you can actually, you state who you want your property to be devised to. Or you can just put it to your estate, which means that they'll pay off all of your expenses, and then they will decide based upon your family how you want it shared up based on your instructions. Now, when you die without a will, the law itself determines how your assets are going to be distributed. So if you die without a will, and no children, so just a wife or a husband, they get all. Everything that you've left behind, they take all. If you die, you left a wife and children, or 1 child. The wife gets half, and the 1 child gets the other half. So if they, let's say you left 2 children when you died and a spouse, the spouse gets half, and the 2 children share the other half. So they'll get quarter and quarter. You understand how it works now?
I understand, but what if I have more than 2 children?
What do you mean? If you have 6?
If I have, you hit the hammer right on me. If I have 6 children.
If you have, and you left a husband?
No, I'll leave my 6 children. But let's say I leave under 6 children.
You have 6 children and you left your husband.
Yeah.
Okay. Hello? So if you have 6, yeah, I can hear you, but the mute it so I can hear, because it's making a lot of noise.
All right.
So if you are, okay, so if you have 6 children and a spouse, it is still half goes to the spouse, and the 50% is shared between the 6 children. If you have no spouse, then whatever you leave between your 6 children.
So, Ms. Archer,
Yes.
say you don't have a husband, but your parents are alive and you have children. How does that work?
No. It follows an order.
Okay.
You have no husband,
Mhm.
and you have no children.
No, you have children. Say
Uh-huh.
you have 3 children. but
Mhm.
Say your mother is still alive or your father is still alive. Do they get
Mhm.
anything?
No, not like that.
Oh,
No,
okay.
no,
Oh,
no. It
okay.
would just be split between your 3 children.
Oh, okay.
So let's say if you have no spouse, right, and no children, but you have grandchildren, it will go to your grandchildren. Now, if you have no spouse, no children, and no grandchildren, then it goes to your mother and your father.
Will that change if a will is in place?
Yes,
Okay.
follows the will. And that's why it's always important to write a will.
So, Miss Archer, one moment. The law that says, well, I heard of it, that the oldest surviving son,
No more. It's being
that's
repealed.
outdated.
Yes, it's being repealed.
Okay,
Does not exist.
okay.
So always remember that. If it's just you and your husband, whichever one dies, the other one takes all. If you have children, then it's split 50 for the spouse and 50 for the children. And if you don't want it to go that way, then you need to write a will. Because if you die and you have no husband, no children, no grandchildren, no mother, no father, then it goes to your brothers and sisters. If
Ms.
you have
Archer,
no, go ahead.
what if there's a case whereas you left a will, right? And in your will, let's say if I have 2 kids and one is A and one is B, and I left it for A and B, but B dies before me. When it's time to probate her estate, she doesn't get any, because B has already died, and even though B has children, would her children be entitled to get whatever I was leaving B?
Yes.
Okay, even though she died before I would have died. Okay. So when I doing like letters of probate, I'll have to list basically all the grandchildren. They're gonna be the heirs of law.
Yeah.
Okay, cool. Okay.
Any other questions? So I see you and you understand how to not as yet. So even if you look at tenancy in common, A can also sell their share because it's separate property. Not separate in terms of physical separate, but he has a separate interest. So the rule, when an attorney is looking at a root title, in some documents, it doesn't state that this is a joint tenancy or this is tenancy in common. You wouldn't see those words. So what they look for is and they try to figure out, is it a joint tenancy or is it a tenancy in common? And there's a rule of thumb that you always presume a joint tenancy unless either there are words of severance or it is one of equity's 3 special cases. And those 3 special cases is where equity would presume a tenancy in common, even if there are no words of severance. And the first one is where the co-owners are business partners. So they would assume that it's a tenancy in common. Why? Because rights of survivorship is not appropriate in a partnership. It doesn't go with a business dealing. The second, own property is a mortgage, and the co-owners are the lender. So it's normally assumed that it's a tenancy in common. And third is where there is a purchase in unequal shares. And so it is presumed in equity that the arrangement is a tenancy in common. Earlier that joint tenancy cannot be severed and converted into a tenancy in common. Severance is possible in equity. So the tenant in common doesn't have to ask the other tenants to sever. All he has to do is advise them that that is what he intends to do. And it becomes a tenant in common. But when he sever, that does not affect the rights of the other members of the group. They still remain as joint tenants in whatever is left in the property. So any questions so far?
Ms. Archer,
Yes.
would there have to be a vote to say, well, I could sell my piece? No way.
What you mean if it's joint tenants?
Yeah.
Because tenancy in common, you could do whatever you want. That would be the best approach to take.
Okay.
Yeah.
Oh, okay.
You could just look around and you could see a lot of people who have passed, not just during the pandemic or before. Where you see properties where you would have known elderly persons were living in, and you see that the homes are just going down to the ground. That's because people cannot agree. And what to do with the property, who it's to go to. So now you understand that when you decide to purchase a piece of property, or you decide to go to the bank in order to obtain a mortgage, what you're getting is you're getting rights over that land. Yes, you will have exclusive possession of that land when you move into your house. But always remember that the land itself belongs to the crown. That is why the crown has the right to actually acquire land when they want to put infrastructure in place. And they will give you fair market price for your land. But you don't own land. You interest in land, and you have rights over that land. Everybody understand that part, right?
Yes, sir.
Yes,
Yes,
sir.
sir. Okay. So for next class, we're going to talk about the conveyancing process. And we're going to talk about the cost that's involved. So those of you who are, if there are any figures that I mentioned that are too low, because things go up, Oh, Lord. No, I'm saying for next class, for chapter 2, we're going to talk about process. And if there are any figures that have changed, be happy to share with the class. So I'm going to work with Miguel to get the schedule ready. So you
Can
could
you repeat
be
that one more time, please? You cut out again.
cut out again. I don't know why. It only happens on Mondays. No, I said that next week is on the conveyancing process. There are some figures involved in terms of charge. There have been any changes, feel free to stay what they are so everybody could be on. We're all here to learn. So next week we'll do chapter 2, the conveyancing process. And let me see chapter 3. I may do 2 and 3 together. If you don't think that's too much. You have your book in front of you?
Yes, ma'am.
Okay. You think you can do 2 and 3 together? Because I know everybody works, so.
Model 2
Let's
seems
do one
like a
stake
lot.
Let's do one stake at a time.
All right, okay. All right, so we'll do
Oh, let's
model
see what
2.
happens when we get to class.
Okay, so we'll do
Monday.
model 2.
Yeah.
Okay, we'll do model 2 and then we'll see from there. Okay, so read over chapter 1 again. Go ahead.
Oh, I was just gonna ask, I see you had 4 cases at end of module 1, and I started trying to find it. You guys perhaps have copies of those cases, or we'd have to go and seek them out elsewhere.
These 3 here. Leave it to me. I'll send it to you. But I prefer to focus more on the Bahamian cases, which I will send to you. Yeah, I'll send you the Bahamian cases. As we go through the chapters, I have some Bahamian cases I'll share with you. Quite long. Some of them are like 20 pages long. So I'll see what I can find for the next class and send it prior to so you can read it.
Okay, thank
Ms.
you.
Archer,
Okay, yes.
just a quick question. I mean, this is my
Go ahead.
first time in one of these courses. How
Go
do we
ahead.
communicate? How can we communicate with you? Do you have our
Email.
email like when we first registered?
Yeah, my email is on the one Miguel sent today with the with the link to the class. CM Archer. If you look in the list. You see it?
I'm looking right now to see.
Yeah, I'm there. I'm there.
Okay. CM Archer. Okay. Yahoo.
That's
correct?
me. Yeah.
All right.
So you can just shoot me an email and if it's something that we have to discuss, I could always give you a call.
All right. Thank you.
Okay. All right. So what I'll try to do is let me see what cases I can find. Bahamian cases that could relate to chapter 2. And we could get started from there. And I'll send them on to you. And I prefer if you read them before you come to class, because that's the only way we could have a discussion. Is if you've read it, because otherwise then you'll be there listening, but you wouldn't have read the cases. All right? So be prepared because some of them are long. All right?
Yes, ma'am.
Okay, all right. So I'll see you all
Yes, ma'am.
next week. Please reread. Any questions, send it. And then I'm going to send you all some cases. Okay?
Okay.
Yes.
All right.
Okay.
Okay. Good night.
Good night.
Okay.
Good night.
Good night.
That wasn't bad.
No, it was not bad.
Sorry, I don't my mic is off.
I'm not going to kill you, you know.